International maritime lawyers, career prospect and qualification required. An international maritime lawyer is a professional eligible to practice law in a given jurisdiction or country with the specialty of legally dealing with maritime matters. This specialization may be attained directly through offering legal services on maritime matters or through advanced education in the subject, such as by means of obtaining a Master of Laws in international maritime law or by both. To build further subject matter expertise, one may even pursue a doctorate of philosophy in any aspect of international maritime law. The niche subject of international maritime law is a whole world in itself, offering diverse professional avenues to contribute and cater to international and national needs. It serves to create an environment for smooth trade flow alongside global frontiers through the most cost-effective mode of transport, shipping. Subject of international maritime law. Taking up legal profession in this specialty of international maritime law requires one to be adept with everything maritime, that is, matters related to the marine areas, the seas and ocean, such as natural resources including fisheries, marine life and oil and natural gas found therein, as well as ship and people serving and traveling on the ship. In doing so, a maritime legal professional may interface with the study of international law and national law because the marine areas which harbor critical resources and are used for transporting around 90% of the global trade lie within and beyond national jurisdiction. Also, a maritime lawyer will interact with private and public facet of law because the determination of what is national is effected by the public and private interest in the maritime sector. The public aspect is commonly referred to as the law of the sea, while the private aspect is the shipping law. International environmental law. The protection and preservation of the marine environment are today at the center of international concern since it impacts the future of the planet as a whole. This is where a maritime lawyer may apply international environmental law, including on climate change. This subject in itself expands from evading the threat of global warming resulting directly from the emission from the shipping sector to the preservation of marine species from other menaces such as illegal, unreported, and unregulated or IUU fishing, which impact global food security and the marine ecosystem. International human rights law and maritime labor law. Also, seafarers and fishing personnel are often victims of inhuman or unsanitary or brutal work conditions. Therefore, this brings into a dimension that the study of human rights is a pertinent subject in the maritime sector. The COVID-19 pandemic evidenced the vulnerable position of the human element in the shipping industry, where the seafarers, being frontline warriors or key workers transporting essential to meet national and international demand, face major hurdles in disembarking from ship due to the stringent lockdown regulation in each country. Hence, the maritime sector also summoned the understanding of maritime labor law, maritime security law, and maritime safety law. Besides, maritime lawyers may interact with security issues or refugee or migrant crises, for instance with the Rohingya Muslim fleeing persecution in Myanmar, fire fishing trawlers to seek asylum or ship with stowaway or illegal substances or materials on board ship and etc. Further, maritime safety matters may be subject dealt within by maritime lawyers. Shipping law, ship finance. External finance is sine qua non in the shipping sector since the building, acquisition, operation, management, and disposal of a ship are capital intensive matters. Hence, a maritime lawyer may professionally contribute to matters impacting ship finance as well. Ship registration and allied matters. Also, a ship, much like human with citizenship, is assigned a nationality of the country it is registered with and whose flag it is entitled to fly. Ship registration serve to impose the rules and regulation of the country whose flag the ship flies, while also extending such country's protection. Characteristically, ship registration can be closed to only nationals or open with no restriction or hybrid, and the consequences of each variety affect stakeholder rights and liabilities. Here, a maritime lawyer's role extends to contributing toward ship registration and allied matters that arise therefrom. There are other matters that are also dealt with by a maritime lawyer, such as companies or organizations engaged in shipbuilding, sale, purchase, and acquisition of ships, and their operation and management. International trade law. Often shipping operations are not carried out by ship owners themselves but by charterers. Also, ship may only be one of the many modes of transport for a consignment to reach a customer. This equation displays professional opportunities for maritime lawyers in assisting ship charterers, freight forwarders, multimodal transport operators, and etc. Also, in the carriage of goods by sea, the rights and liabilities of stakeholders are complex. This is because the responsibility and possession of goods, which may characteristically be perishable, non-perishable, hazardous, noxious, or flammable, need to be ascertained through shipping documents such as the bill of lading, charter parties, multimodal transport document, international convention, and etc. In this direction, a maritime lawyer will also interact with international commercial terms adopted by the International Chamber of Commerce, which harmonize international trade by providing the costs, risks, and liabilities of the stakeholders. Carriage of people by sea. Besides, the carriage of people by sea is a much more delicate affair, especially in terms of the liability regime that may require the engagement of a maritime lawyer, particularly in the hospitality or cruise industry at sea. Law of salvage, towage, and pilotage. Further, a maritime lawyer contributes to ascertain the rights and liabilities of a ship or cargo owner or master or agent of a ship where maritime emergencies and accidents occur, and even in determining the incentive for the saving of an endangered ship under the law of salvage. While salvage is a recourse during danger, the law of towage is another subspecialty of a maritime lawyer to aid in contractual towing of a vessel by another, irrespective of danger. Further, a maritime lawyer utilizes the law of pilotage to assist a ship entry into specified areas by a person, a pilot, with specialized knowledge of the local condition and navigational hazard in that area. Ship recycling. When ships are damaged beyond repair or near the end of their life, they are recycled for a price. However, since ships may have carried reactive or flammable or dangerous or other hazardous substances on board, their recycling need to be safe and ecologically sound, a matter which is now codified in the Hong Kong International Convention for the Safe and Environmentally Sound Recycling of Ships 2009. Hence, professional opportunities for maritime lawyers in the ship recycling industry are huge, and they also require the application of relevant national labor and environmental laws. Ship arrest. Importantly, where shipping dispute arise such as an ownership, salvage, towage, hiring, or maritime labor or liabilities for environmental damage, there may accrue a maritime claim. Thank you.